I had thought at one point, when asked to speak about the Fourth Amendment, that I would say, okay, there isn't one, any questions? Because that's essentially where we are. The second half of that is, I often thought that I would entitle my speeches the One Fourth Amendment, because I think that's about all that's left of the Fourth Amendment. And I do want to start with June 15th of 2006. The last term of the United States Supreme Court, I think, is somewhat devastating. There was a case that came out on June 15th of 2006 called Hudson versus Michigan. Hudson versus Michigan was a no-knock case in which the court discussed whether or not a violation of the no-knock provisions was suppressible. And why I think this is important doesn't have anything to do with DUI defense, but there was a 5-4 decision saying that a violation, a clear violation of a constitutional requirement does not require suppression. And it was Scalia's majority opinion for the court, which discussed the exclusionary rule. And I think on July 15th of 2006, you're going to see, you have seen the start of the death of the rest of the 1/4 of the Fourth Amendment that's still alive. I mean, it's on life support, and Dave talked about the hospitals. The Fourth Amendment is in there, it's sick, it's got terminal cancer, and it's about to die. In Hudson, the court said, suppression of evidence, quote, has always been our last resort, not our first impulse. Hudson can be found at 126 Supreme Court, Reporter 2159. Secondly, Scalia said we have, quote, long since rejected, close quote, the expansive dicta in Mapp versus Ohio, i.e., gee, when the Constitution is violated, we have to exclude evidence because we don't want folks convicted based upon constitutional violations. That's gone. He specifically said it's a last resort. We are rejecting the expansive dicta that has been in our cases forevermore. He said that is, the exclusionary sanction is an issue separate from whether the Fourth Amendment rights of the party have been violated. So he is saying, look, I don't care whether the Fourth Amendment, your client's Fourth Amendment rights have been violated. What we're going to do about it is a completely separate issue. So let's assume the Fourth Amendment applies. Do we exclude? In that case, they said no for a no-knock violation. He also said, this is again, the but-for causality is only a necessary but not a sufficient condition for suppression. Meaning, gee, but for this violation, they wouldn't have gotten the evidence. Doesn't make any difference. It's only necessary, it's not sufficient. Finally, he said, and this is the part that I like, because Justice Scalia is such a knowledgeable litigant, I would suspect, Don Samuel argued the Randolph case in front of the Supreme Court. He said it was a great experience. I said, don't ever send me up there. I'd stand there, they'd ask me a question, and I said, which one of you son of a bitches have ever looked a jury in the eye? Which one of you people have ever argued a motion to a judge that used to be a prosecutor? Which one of you people have ever cross-examined a cop you know is lying? Which one of you have ever made an argument to a jury to understand what the hell's going on when somebody is going to go to prison? Not one of those people, not one of them. And I would never be able to sit there and argue to him. And Don said, ha, ha, ha. So I'll let Don argue any case that we're bad enough to get up to the Supreme Court. Actually, I think it is, at this point, it's ineffective assistance of counsel to get the Supreme Court to rule on your case. Well, because all you're going to do is make bad law for all of us. He said, Justice Scalia, my buddy, A civil suit is, quote, an effective deterrent to police conduct because of the, and I quote, increasing professionalism of police forces. You got to read this. You got to read this opinion. How many of you have read Hudson versus Michigan? It makes you sick. I mean, it's horrible. Suppression is what he calls a, quote, massive remedy, close quote, and social costs, close quote, are more important than Fourth Amendment remedies. Social costs, that is the social cost of excluding evidence and letting the guilt, remember the old, the guilty go free because of the constable blunders? That's it. He said, no more. Social costs are more important than Fourth Amendment remedies. All right? I'm telling you, Hudson is the death knell of the exclusionary rule. So, now do you want the bad news? No. That's about as bad as it gets. I'll tell you, well, no, I won't tell you. I was going to say that I had an opportunity to go hunting with Justice Scalia. Unfortunately, I couldn't make it. I'm a vegetarian and didn't want to kill Bambi with him. But I actually, that doesn't have anything to do with it. That's just devolving into war stories. Okay. Let's talk a little bit about the lack of Fourth Amendment protections in DUI cases at any rate. I think that that we can start with the proposition, I think, outside of the issues that Dave has talked about and Gus is going to talk about after the stop, what happens when they attempt to get evidence in your Fourth Amendment remedies there. You know, the initial attack on any DUI is the stop itself. It is always, virtually, going to be a warrantless stop, right? Always. So you always have a motion to suppress. I don't care. And I disagree with Dave. He's a very careful, precise, intelligent litigant. And he says, well, here are some reasons you may want to file a motion. Here's some reasons why you don't want to file a motion. Do you file a motion to win or just for your client? I'm sorry. File a motion. File it every time. Litigate it every time. You know, you never, the worst that happens is you lose, right? You're in the same situation as you'd be in anyhow. What's the worst thing that can happen to you besides making bad law on appeal? Thank you. What's the worst thing that can happen to you? You lose. You're in the same exact position. What's the best thing that can happen to you, even if you don't win the motion? Well, you win the motion, of course. That's the best thing that can happen to you. But you know, you're going to get something. I've never had a suppression hearing where I haven't gotten something. Something that the cop says, something that happens during the course of it. And I'm sorry, my position is always file it. You're always going to have a motion. It's always a warrantless stop. It's always a warrantless seizure, right? So what do you lose? What do you got to lose? That's my opinion. I may be wrong. Pretext? Is there anything you can say with regard to the original stop? Of course, you have the right to say, you can't stop me. You shouldn't have stopped me. Here's what the rule is in Georgia. And this comes out of State v. Kennington. I'm sure everybody's aware of that. I know Dave is. 264 Georgia Appeals 912. This was when Ronnie Batchelor was sitting pro hac up in the state court in Gwinnett County. The behavior, and I quote, the behavior giving rise to an officer's reasonable suspicion need not be a violation of the law. That's great. All right, so you can be completely law-abiding and get stopped. Completely law-abiding to get stopped. I lost a case in the Fourth Circuit in which my client was driving in Greenville, South Carolina. This is a drug stop, and it's a drug case. And he was the only one going the speed limit. You know, you're on the interstate, and people are zipping by 90 miles an hour. He's going the speed limit. The cop stopped him because he was going the speed limit. He was going too slow for conditions. And I thought, I am going to kick ass in this case. I'm going to look like such a hero. I mean, I walked in, chest puffed out, you know, put that cop on there. You know, and I cross-examined him. He did nothing wrong. He was going the speed limit. He didn't see any violation of the law. There were 100 cars going by him at the same time, you know, doing this. I mean, I cross-examined him for an hour, and I'm having a blast. And he says, well, the guy was going, he was impeding traffic. I mean, he was going too slow. He was going the speed limit. That's what made him suspicious. When you obey the law. Judge denies the motion to suppress. I said, okay, here's my argument. So if you obey the law, that's reasonable suspicion to be stopped. And the judge says, in this circumstance, yes. I said, no way any appellate court's going to uphold this. I got an unpublished decision. That's how bad it was. An unpublished decision from the Fourth Circuit saying, yeah, that sounds suspicious to me if you're going the speed limit. All right. So we'll start with that. In State versus Kennington, the behavior giving rise to an officer's reasonable suspicion need not be a violation of the law. Even if the driver's actions do not amount to a per se traffic violation, an officer may have a reasonable, articulable suspicion that a traffic offense was being committed. What bullshit? You're not violating the law, so you can have a reasonable suspicion that you are violating the law? What the hell is that? What does that mean? Can anybody give me an idea of how watching somebody not violate the law gives you a reasonable suspicion that they're committing a traffic offense? What, are you kidding me? What planet are we on? Let me talk about reverse logic. We cannot require an officer to make immediate judgments regarding whether every element of a particular crime has been established before making brief stops. Aha! Who said that? Thank you. So you're watching them not doing anything wrong, but they haven't met all the elements of a crime. They haven't met any elements. I mean, it confounds. Who comes up with these things? They sit, the Court of Appeal sits there and says, oh, how is this defendant? What are we thinking about? How can anybody think of that? How can anybody think of that? I mean, well, in the fact that it is later shown that some element of the crime was not satisfied will not invalidate the stop if the officer acted in good faith in stopping the car. All right, here's what's dangerous, completely dangerous. Good faith exception to the exclusionary rule, right? U.S. v. Leon, etc. That's a federal rule, right? The good faith exception applies, listen to me, the good faith exception applies to a search warrant that was issued by a neutral and detached magistrate, and the officer relies upon it in good faith. Correct? Am I correct?
Federal.
Yeah, well, am I correct about that? Yes. It applies to a search warrant issued by a neutral and detached magistrate that the officer relies upon in good faith. Okay? It applies to search warrants. That's what the good faith exception applies to. Even in federal court, we know that there's no good faith exception in Georgia, statutorily. Even for written documents, okay? Even for search warrants. What does this say? What does this piece of decision say? What does it say? There's a good faith exception for warrantless stops based upon no crime being committed in Georgia. Does it not? Based upon the good faith of the officer in stopping the car? Now we have good faith incorporated into warrantless searches in a state that doesn't even have a good faith exception. How about that? Am I giving you any good news yet? No. And I'm going to continue. The social costs, yeah, the social costs to DUI. All right, so I think this is completely wrong. I would challenge it at every step of the way, because not only is there no good faith in warranted searches in Georgia, and in federal, even in federal court, there's no good faith exception to warrantless searches or seizures. And that's precisely what this language reads into the law of Georgia. Completely wrong, completely off base, and don't let anyone tell you that it's not. I mean, I get sick when I read this. And only smart guys like Dave can handle it. The question to be decided is whether the officer's motives in actions at the time and under all circumstances, including the nature of the officer's mistakes of law versus mistake of fact. Y'all are aware of all of those, correct? All right. If any were reasonable and not arbitrary or harassing. Now, this decision is in 2003. What's the good part? What's the silver lining of what you just heard? I mean, great response. Listen. The question to be decided is whether the officer's motives and actions. Didn't Wren say motives and actions are irrelevant? There's no more protectual stops. He said, and he's the smartest guy in this room, there are no more protectual stops. Silver lining here says you can investigate the officer's motives. You can investigate the officer's actions at the time and under all the circumstances, including the nature of the officer's mistake. Remember the difference between mistakes of law and mistakes of fact. If any were reasonable and not arbitrary. Did we just read back protectual stops into the law of reasonable suspicion in Georgia? I would say, okay, if you're gonna screw me with the shit in this decision, at least let me get on with the good stuff in this decision. This brings back, I suggest to you, ladies and gentlemen, that you can pretextual, arbitrary, harassing officer motive stops are still alive in the state of Georgia, and litigate the hell out of them. Dave does and Dave would. Because, notwithstanding what he said in his speech, he ain't giving up on that.
Will now.
See? He will now, he says. And I don't want you folks, I suggest to you, to give up on it either. Remember, Wren was a probable cause case. Every word in Wren, every single time they use a reason for a stop, it was probable cause. The officer had probable cause because he witnessed a violation. Don't let Wren stop you from litigating reasonable suspicion stops. Reasonable suspicion stops that I still think, under Georgia law, in this both good and bad case, you can now continue to litigate. So don't necessarily listen to Dave on that one. Remember, if it's a reasonable suspicion stop, I still think you can litigate pretext. I still think you can litigate the issue because Wren was a probable cause case. Folks, you got to read these cases. Don't read the blurb. Don't read the, oh shit, we're out of luck. You know, because now we can't challenge any traffic stop. That's not true. Wren's probable cause. Please go read it again. That was, by the way, State versus Keddington, 264 Georgia Appeals, 912, 592 Southeast 2nd, 532, 2003, Georgia, 2003. Now, Now let's go from, that's the reasonable suspicion test. So anytime you get somebody that says, like we were talking about, the weaving within the lane, that the courts, that apparently the courts in Georgia say is grounds for stopping somebody, I think you can litigate that successfully. Go from reasonable suspicion to probable cause. What's the test on probable cause? The test of probable cause requires merely a probability, less than a certainty, but more than a mere suspicion or possibility. Yeah, that makes everything clear. To arrest a suspect for driving under the influence, an officer need only have knowledge or reasonably trustworthy information sufficient to authorize a prudent person to believe. Well, a prudent person wouldn't be out there .25 driving down the road, so we're not worried about prudent people anyhow. Sufficient to authorize a prudent person that the suspect was actually, what? What are the elements? Actually in physical control of the vehicle, physical control of a moving vehicle, while under the influence of alcohol to a degree which renders him or her incapable of driving safely. Bunch of elements. Actually in physical control, and the courts have said this 100 times. Actual and physical control of a moving vehicle. I know you all have had the officers in the first tier encounter going up to somebody sleeping at a stoplight. And I love the sleeping at a stoplight at 3 o'clock in the morning. I was tired. You know, it's better, it's much safer for me to sleep than drive, you know, like, sleeping in a parking lot, sleeping in, you know, next to the, sleeping next to the place that they just finished burglarizing while drunk. You know, boy, I just got out of there with the loot and had to take a nap in my car outside of the Napa store in, you know, Lighthouse, Georgia. You know, sorry, that's, I've been there in court many times. What?
It's next to pull my finger.
Yeah, next to pull my finger, right. Very good. All right. So the first tier encounter, I mean, there's no probable cause there, but it's still, remember the first tier encounter? You don't see him do anything, you walk up, the cop, you know, says, what are you doing here? And you say, well, what the hell do you think I'm doing? You just woke me up. I've been sleeping. Is that against the law? No. Well, what are you doing here? Sleeping. Well, what are you doing here? Sleeping. You know, my favorite response was up in the old days when Gus McDonald was still a tadpole, not a fully developed frog, was I had a case in White County. You remember, in Helen, Georgia, during Oktoberfest. And they used to do, I don't know whether they still do, the alphabet. Now maybe they do it backwards, but they used to do it like forwards because the cops didn't know the alphabet either. Especially in White County, and in fact, when I started practicing in White County, there used to be, and this is true, more people than teeth. So, guy gets pulled over for DUI, and he gets out, and it's on a video, and I still have this video, and the cop wants him to recite the alphabet, one of those really significantly scientific tests that they use. And he says, and I thought this was clever, I thought this was great, ABC DUI. And he starts laughing his ass off. Like, aren't I a clever son of a bitch? You know. And I started clapping, I thought it was great. You know, that's very clever. And the cops look at him, you know, cops, and he arrests him. And I said, listen, the guy clearly had his wits about him. He clearly was intelligent enough to make a joke. He clearly understood and came up with that off the cuff. I thought that was pretty damn good. Judge kicks the case and he said, I thought that was pretty damn good too. For example, and I'm reading from Slayton versus the state. It's a September 22nd, 2006 case. 2006 Westlaw 2708952. 2006 Westlaw 2708952. It is true, as Slayton points out, that it has been repeatedly held by this court that the presence or odor of alcohol in a driver's breath does not by itself import an inference that the driver was impaired, based upon case I know you all know, State versus Gray, because I see it repeated all the time. State versus Gray at 267, Georgia Appeals 753. I like Dave quoting Justice Banky. Problem with Justice Banky is he'd be dead, and has been for a long time. Likewise, a positive Alka-Sensor result shows only the presence of alcohol, not that the driver is intoxicated, and it is less safe for him to drive. All right, so what do we got here? We got probable cause to arrest, meaning that you're in physical control of a moving vehicle. Officer need only have knowledge or reasonable trustworthy information to agree to a degree which renders him incapable of driving safely. But odor of alcohol isn't enough. Alka-Sensor isn't enough. What is enough? There has to be some other circumstances. There have to be other circumstances. And I know your clients usually give them the other circumstances. You know, you fall out of the car when you ask to get out, right? You get out and, you know, you have to steady yourself against the car. You get out and offer the officer a shot. You know, just those other physical circumstances, but probable cause. Probable cause if you're going to get stopped. And you get stopped under that reasonable suspicion crap we just went through. And then there is an odor of alcohol. And you flunk an Alka-Sensor test, or the Alka-Sensor shows that there's alcohol. That's not enough. That's not enough. Those three circumstances are not enough to arrest you. And now we're into the Wren territory, because Wren is probable cause, as I said before. And that's what we're talking about in these cases. You got to separate the difference between reasonable suspicion and probable cause. And that's generally the probable cause test in Georgia with regard to the DUIs. And that's over and over and over and over again, based upon State versus Gray. Let me give you another one. State versus Sanders at 274 Georgia Appeals 393. Dave knows all these cases. If I didn't have the site, I would say State versus Sanders, and Dave would say 274 Georgia Appeals 393. Right in about the middle of the volume, right?
Something like that.
Okay.
It's Colonel Sanders.
Yeah, it was Colonel Sanders. Wiley Sanders. Judge Stone granted the motion up in Towns County, the only motion he's ever granted in his 20 years on the bench, which was upheld on appeal. So that's actually a pretty good case. Now, what about roadblocks? What about roadblocks? They suck? They do. You know that roadblocks, any decisions with regard to roadblocks starts with Delaware versus Prowse, the Indiana case. In Georgia, there are several recent and good cases with regard to roadblocks and the conditions that need to be met with regard to roadblocks. Let me refer you to two of those. I don't know whether anybody else is going to talk to you about these particular issues. Thomas versus the state is the most recent roadblock reversal at 277 Georgia. What page? Yeah. 8 close. 88. Begin with an 8. Thomas versus the state, 277 Georgia Appeals 88, is a Recent reversal with regard to roadblocks. State versus Morgan is another roadblock reversal. It will give you all the requirements for what they have to do with regard to roadblocks to make them constitutional. 267 Georgia Appeals 728. Those are two roadblock cases that I commend to you for purposes of deciding whether or not the roadblocks are being constitutionally comported with. One recent case in March of this year, State versus Brown at 278 Georgia Appeals 457, was a Newton County Superior Court case. Newton is right next to light my fart and pull my finger, if any of you have been in that jurisdiction. In Newton, the court found that there was an improper second-tier Terry stop. Brown pulled out into a 4-lane highway and the officer followed him for more than 2 miles, contending that he saw Brown cross the white line twice. The officer stopped Brown for suspected drunk driving. Following too closely, weaving, crossing the line, all our favorites. But you know, in this particular case, the officer, however, did not smell alcohol in Brown's breath, so he did not administer any sobriety tests. The trial judge discredited the officer's testimony that Brown had been weaving. Discredited the officer's testimony that he'd been weaving. So I think that's great. The trier of fact is not obligated to believe a witness, even if the testimony is uncontradicted, and may accept or reject any portion of the testimony. I mean, that's the rule. We don't ever see it happen. We don't ever see it happen, but that's clearly the rule. And in litigating the first stops, I mean, that's where you have to go. So, the stop, reasonable suspicion. The stop, roadblock. The stop, pretext is still alive. I'm telling you, it is still alive. That language is based on whether it's arbitrary and harassing. Some older cases, State versus Webb at 193 Georgia Appeal. I don't have any materials, so if you want any of these, you got to write it down. 193 Georgia Appeals 2, whether the officer's actions were reasonable and not arbitrary and harassing. So I still think that's alive. I suspect that other folks are going to talk about breath, the particulars of breath and blood. I want to make one other point with regard to the Fourth Amendment. I am starting to file Fourth Amendment challenges to people's statements, whether they're, in custody or not, because that's a Fifth Amendment issue, right? We know that in DUI cases, when you're pulled over on the side of the road and you're stopped and you can't go anywhere, you're clearly not in custody. Because none of those folks at the Supremes have ever been pulled over by anybody and stood on the goddamn side of the road while 18-wheelers are whizzing by and cops with a gun are standing there telling you you can't leave and you got to answer these questions. No, that's never happened to anybody, so you're clearly not in custody. You're not in custody for the Fifth Amendment. Fifth Amendment. Fourth Amendment. What does the Fourth Amendment prohibit? Searches and seizures, taking things from you, right? What is it when they ask you a question? What are they taking from you? The contents of what's in your head, aren't they? They're taking something with you. They're taking what you think. They're taking what you've done. They're taking something from you. So I've started challenging confessions, even statements, as a Fourth Amendment violation. And I've got a long brief like Dave, I would be glad to provide it for you. As a Fourth Amendment taking, as opposed to a Fifth Amendment challenge. Because we've lost the Fifth Amendment, not we, you all. I've never lost one of those. But, you know, all of that's been litigated over and over and over, and even the Supremes, who have never been stopped, don't say it's a Fifth Amendment violation, but I'm saying it's a Fourth Amendment violation. And I guess the answer to all this, when I say Fourth Amendment, I'm relying both on the federal Constitution, as the statute says, but primarily on the state Constitution, because I think the federal Constitution, the federal Fourth Amendment, is going the way of Hudson versus Michigan. It's going to be gone. I think we obviously all have more protection, I believe, under the state statutes and state constitutions, and I'm putting those out front. We used to go to the federal courts to rely on the vindication of our constitutional rights. We no longer can do that. We're back to the old days of coming back to the states, and I don't necessarily think it's a good thing, because I'm old enough to remember when people argued the doctrine of interposition. Does anybody know what the doctrine of interposition is? That the federal government can't interpose itself between a citizen of a state and the state's rights to do what it wants. That was the old argument against segregation, and for segregation and against integration, the doctrine of interposition. So now we're back to arguing states' rights. But in Georgia, the state constitution obviously gives you more protection than the federal constitution. So why isn't it a Fourth Amendment right if the government stops you and seizes you and takes the contents of your head? Tell me why it's not. Good. Because when I say that to a judge, they give me the same blank stare and they say, aha, well, that's the Fifth Amendment. So the state, you're taking something from me. You're taking my thoughts. You're taking what I have inside me. Now that's different with regard to implied consent, because the implied consent law says you can take that. You got to deal with it in its particulars. It doesn't say anything about your head, the thoughts in your head. And I think the sanctity of your head is the most important thing in the world. The sanctity of my head's a little confusing. It's a little bit muddled in there, as you can tell. But I suggest that you look towards the Fourth Amendment for things like that. Think outside of the box, is I guess my answer to that. So I'm developing Fourth Amendment challenges to that. I don't know whether my time's up. I hope it is, because I don't have anything else to say. Does anybody have any questions that I probably can't answer? Okay, good. Thank you very much.
Thank you very much, Bruce, for that informative speech. I have a whole new perspective on the Fourth Amendment now.